ladies and gentlemen of the jury, the state has now rested its case in chief. That does not necessarily mean that you've heard all the evidence that will be presented to decide this case. The defendants have no burden of proof in this case, but they are given an opportunity to present evidence to witnesses and exhibits. We will do that after lunch if they wish to do so. If they choose not to present any evidence, then we will go into closing arguments. But we're not there yet, so please, once again, do not discuss this case among yourselves. You can leave your notebooks in the chairs and go with the officers for lunch. It'll probably be a little bit longer lunch today, probably more about like 1:30 when I see you again. So have a good lunch, folks, and go with Officer Thompson. Evan, you may be seated. All right, do we have a motion from the defense?
Your Honor, at this time, we would make a motion pursuant to Rule 29 of the Rules of Criminal Procedure that the state has not met their burden as to each element of the offenses charged. I do have some case law, if I could present it to the court.
Are you?
And here's some copies for you all. Your Honor, I'd like to go backwards, if possible, in this case. We're faced with a 3-count indictment against Mr. Davis. The third count alleges aggravated child abuse, so I'd like to start there. Your Honor, the elements of the offense here require that the state prove beyond a reasonable doubt that the defendant knowingly, other than by accidental means, treated a child in a manner as to inflict injury, and that serious bodily injury resulted, or that a deadly weapon was used in the commission of the offense. Your Honor, I believe here that there has been no proof in this case that would satisfy the mens rea element as to this count of the indictment. I've passed up State versus Hansen, which for the record is 279 Southwest 3rd, 265, and State versus Ducker, which is 27 Southwest 3rd, 889. Your Honor, in each of these cases, the court addressed the mens rea element required to establish aggravated child abuse. And in each of those cases, the Tennessee Supreme Court has talked about the fact that aggravated child abuse is a nature of conduct offense rather than a result of conduct offense. So here, it's our position that that would require proof that the defendant knowingly treated a child in a manner as to inflict injury. So the knowingly has to apply to the acts and the intent, not to the result of the conduct. So here, I don't believe that there's any proof in the record that would support, even under the theory most favorable to the state, that that was present in this case. There's been no evidence that anyone was aware that Mr. Freeman was in the car, that the defendants were aware that that was the individual that was there. I think we've heard some proof that the state would maybe try to argue that the act was in response to the initial Honda that we had seen on the screen. However, the proof has indicated that that was during school hours, and there's no proof to indicate the defendants would have known a minor was in that car. So even, I believe, under a theory of transferred intent in that aspect, there is not proof that anyone would have had knowledge a minor was in the car or would have had the intent to treat a minor in such a way as to inflict injury. And I don't know if the court had any specific issues it wanted to address on this count before I move forward.
So you're saying the mens rea knowingly applies to the fact that the victim was under 18?
I think you have to have knowledge. You have to have knowledge, and you have to have the intent to treat a child. So if you look at this case law, it specifically talks about how the knowingly modifies treatment of the child, not the result, not what ultimately occurred, but what they were trying to do. And I think each of these cases support that position. And I think that that is going to also dovetail into the second count of the indictment, because the second count of this indictment is pursued as a felony murder in the perpetration of aggravated child abuse. So here, the state would still have to establish an unlawful killing of the victim in perpetration of the aggravated child abuse, but the third requirement is that the defendant intended to commit the underlying offense. So they would require proof here that the defendants intended to commit child abuse, And in the course of that, there was a death. Again, I think that the proof is lacking. I don't think we've heard really or seen any proof about intent as to Mr. Freeman or specifically as to that Honda, or any proof that that would have involved a minor either. And I think I said this before, but the initial video was still during school hours too, which I think also undercuts that theory. Finally, when we're looking to the first count of the indictment, it's charged as first-degree premeditated murder. So the court is aware that that's an unlawful killing. They need a showing that the defendant acted intentionally and that that killing was premeditated. So we know that premeditation requires the exercise of both reflection and judgment. And that also the premeditation has to be formed, even briefly, but it must be formed prior to the act itself. So, I think really the only proof we've seen as close as we can get to what actually happened at the time of the shooting, again, is going back to that video here. So, we see the initial video, we see cars in front of Austin East. The time span, as the court has seen, between when the first car turns onto Tarleton and when the second car follows is a span of maybe 30 seconds between when those cars turn and when a shooting occurs. So it's our position that there's not been any proof introduced directly as to either defendant as to premeditation related to either transferred intent, if the state's theory is that the initial Honda was at issue, or as to Mr. Stanley Freeman specifically. So, and I think that the fact that there was such a brief time between when those cars were together and when the shooting occurred, that there's not the ability to form premeditation in that brief span based on what the state's theory is. So, the court also heard that just as we turn onto Tarleton, the casings are at the very beginning of the street there. That section of the intersection is less than 500 feet. So we're talking about seconds. And again, I think circling back to the age of the defendants at the time is going to be relevant to the formation of premeditation and intent as well. Let's see. Oh, and additionally, I think that in the initial video, if the state's theory is that this initial encounter with the Honda, the unrelated Honda, is a part of the potentially the transferred intent, I think the fact that the blue car turns off of the screen and that the Honda turns around and does not pursue them undercuts this theory. We've heard that there's an altercation, but there's no shooting, there's no speeding off, there's no actual pursuit happening. So I think the fact that there's 8 minutes in between undercuts that argument as well. So I don't believe that there's proof of premeditation. I think that the court has the ability here to, even under the evidence most favorable to the state, dismiss or let the lesser included offense of second-degree murder go to the jury rather than first-degree premeditated murder. And we would ask the court to dismiss counts 2 and 3 of the indictment.
Thank you. Mr. Robinette?
Yes, Your Honor. Ms. Mathis did a great job putting the point together. I just want to add one thing. I don't believe that the aggravated child abuse is a strict liability kind of issue. It has the element of knowingly in there. It's not similar to the statutory rape of a child. They don't have to prove that where the state doesn't have to prove that the person knew that was a person, a minor. So in this case, I believe the state has to prove that Mr. Jordan, Mr. Davis knew a minor was in that vehicle because of the element knowingly in that matter. And that will also go to the second count, because if there's no aggravated child abuse, then the felony murder will fall, Your Honor. And the first count is the premeditation. Like Ms. Mathis' argument, and there was no evidence of deliberation in there. There's no evidence to show that anybody at the time of the shooting planned anything or got out of the vehicle. There's no proof. And the fact that I don't think the state even made its burden to put Mr. Jordan at the scene of the crime, Your Honor, and you heard testimony from Jeremy Hines. They rely on that testimony. And Mr. Hines said Mr. Jordan was not there that day. So therefore, Your Honor, based on that, I ask that all counts be dismissed against Mr. Jordan in this case.
Thank you. General?
seeing that the defense started backwards, I'm going to follow the same path. With regards to these cases, I think the suggestion that there was no mens rea with regards to their actions circling around a senior high school ignores the fact that the majority, if not the vast majority of the people that are coming out of that building are minors. So to suggest that the state has not provided any proof that the defendants had the mens rea or knowledge with regards to the occupation of those vehicles being a minor, I think ignores the fact of the context of where this particular event took place. And with regards to the premeditation aspect of this particular case, once again, that has to ignore the fact that we have voluminous records that present these two defendants posing with their weapons before and after, and having been found with numerous rounds of ammunition at their residence, and the electronic information indicating the desire to acquire ammunition before, certainly is sufficient to suggest to the jury that these acts were premeditated for the purposes of the first-degree murder. So the state believes that there is more than sufficient information for these 3 counts to go to the jury for their consideration of this particular case.
All right, thank you, sir. So when the court examines a motion under Rule 29 for judgment of acquittal, the court has to look at the evidence in light most favorable to the state and draw any reasonable inferences from that evidence in favor of the state's theory. And if a reasonable juror, after doing so, could not find sufficient evidence to find the defendants guilty, then the court itself would enter a judgment of acquittal on that count and any lesser included offenses that could not be supported from the evidence. So at this point, the court looks at all the evidence we've heard in a favorable light to the state. And so I'm going to start from the beginning with count number 1. I certainly believe that the state has met its burden of proof to show sufficient evidence of premeditation. As we've all said many times, premeditation can occur in an instant. I don't think you have to go back and look to when they're arming themselves the day before and going to the school with weapons in their car. I think you can look at what happened when Mr. Freeman unfortunately crossed our paths and they opened fire multiple times into this vehicle, causing the death of Mr. Freeman. That is not a spur-of-the-moment reaction where you just shoot one time and it appears that the bullets are following along a passing car. We have bullets in the front, then the side, and then in the rear as it's going. So this is certainly, I believe, sufficient evidence to show somebody was attempting to kill the driver of that vehicle. We have litigated already on whether or not a juvenile can be guilty of committing child abuse, and I ruled on that in writing, I believe. The statute says a person who treats a child under the age of 18 in such a manner as to cause injury is guilty of that. And a person is anyone, depending upon the statute. Some statute includes a person before birth, but certainly anybody after birth would be considered as a person for purposes of this statute. Therefore, the court found that someone under the age of 18 can also be guilty of child abuse. The argument that the defense are both making in counts 2 and 3 is that the state has failed to show that they knew that the person that they were allegedly abusing by shooting was in fact under the age of 18. It's an interesting question. If you look at a number of the statutes that we have, the intentional and knowing can refer to one element of the offense, but not all of those. So it could be that the knowing requirement is that you're knowingly abusing a child, and you can be reckless as to whether or not they're 18 or younger. I don't know that that's the case here. I'm going to look at it as if every element has to be shown through a knowing mens rea. And so when you look at what does knowingly mean, it means that you're aware that circumstances exist. And so what we have here is we have a number of juveniles in a vehicle around a number of juveniles after school, where a lot of juveniles are leaving the school, and you have Mr. Freeman, who was only 16 at the time. The autopsy pictures certainly look to me like somebody less than 16 years of age, certainly under 18 years of age. And you have entrance wounds into the car as the car appears, approaching, where the person would be looking right at the person coming at them. And so I certainly think under Rule 29 there's sufficient evidence to show that whoever did this knew that the person in that car was under the age of 18, even if they were wrong about who they thought they were shooting at. And so I think it's sufficient in counts 2 and 3 to get it to the jury. I'm not saying the jury's going to find that that's true, and certainly the defense has a good argument to the jury about those, and we'll let them decide, though, if it is proved beyond reasonable doubt. But I think for purposes of Rule 29, it is sufficient, so I'm going to deny the defense motion on that. Has the state filed? I guess not, since they're juveniles, no 609, right?
Yes.